evening, everyone. My name is David Caron. Welcome to King's College. I have the privilege to serve as Dean of the Dixon Poon School of Law. I've had a long love for the law of the sea. Tonight is very special for me. My teacher was a man named Stefan Riesenfeld. He had a strong view about it-loss, which affected me, which was he viewed it as congenitally challenged. You know, every tribunal is born. Some are born with a large caseload. You can be sure the caseload's going to function. And it was a question of how many cases would come to it-loss. It was a question of whether having a dual pathway, one toward arbitration, one toward the court, would be difficult for it. And it has a few judges as well, which is perhaps its own challenge. We have tonight really the person who knows the tribunal as well as anyone, if not better than anyone. And that's Professor Rüdiger Wolfrum. And his introduction will come from a former student of his, Dr. Hester Meyer. But it's a special night. Welcome, and thank you for coming. This is a program of the King's Forum on International Dispute Resolutions, funded by Shell, with a nice gift, and it's been just bringing about a lot of wonderful programs. So, please, Holger.
Thank you for showing up, and also welcome in the name of the King's Forum on International Dispute Resolution. Before I start, a little bit of housekeeping. We now put our events online. You can find them on YouTube. We have an event on the Southern African Development Tribunal that was put online. We had one on international criminal law. And you can find them all through the website of the King's Forum on International Dispute Resolution. I have somewhat reluctantly joined Twitter to announce events, so you can find announcements of events as well as new YouTube videos there. This is the last event for this term. I'm looking at my cell phone because that's going to be the first event for the next term. It's going to be a conversation with Rusty Park on applicable law and patent licensing disputes. That will be in January. In March, we will have the former German member for the Committee for Economic, Social, and Cultural Rights here to speak to us. Those events will not be filmed. Tonight's event is very special for me, and I think a big treat for the end of the term. I have made a list of presenting my former teacher. It's probably never a good idea to have a former student present a former teacher, but it's particularly problematic in the case of Rüdiger Wolfrum. I think the only way to introduce him is to split him into pieces. Rüdiger Wolfrum, the scholar, I co-edited a Festschrift for his 70th birthday, 271 publications. Of course, that was years ago. I have no idea where we are now. Among his minor works, a 3-volume textbook on international law in German. He co-edited a 7-volume commentary on WTO law, which, when I was given the honor of editing one of the volumes, I thought would be his major work, but boy, did I not know Rüdiger Wolfrum. Everyone in international law now knows him as the editor-in-chief of the Max Planck Encyclopedia of Public International Law, which has, I looked up the numbers today, more than 1,600 articles, more than 800 contributors. No doubt, partly that is the reason for him holding many honorary doctorates and being a confrère of our dean in the l'Institut de Droit International. The second part is Rüdiger Wolfrum, the administrator. He was director of the world's most significant research institute on public international law, the Max Planck Institute in Heidelberg. He was president of the German Society for International Law, vice rector of the University of Kiel, vice president of the German Research Foundation, and vice president of the Max Planck Society for the Advancement of Science. That, in its own right, all of that, a distinguished career. A distinguished professor and teacher, yet another slice of Rüdiger Wolfrum, professor in Mainz, Kiel, Heidelberg, a visiting professor in Minnesota. His students nowadays hold academic positions from Dar es Salaam to, yes, I confess, London. His most distinguished students are a judge in the German Constitutional Court, a member of the Human Rights Committee, a member of the German Ethics Council, and I should mention this, all three of them women. So he also played an important role in supporting women in science. Transfer of knowledge and transitional justice, yet another slice of Rüdiger Wolfrum, and another full career in its own right. He is head of the Max Planck Foundation for International Peace and the Rule of Law, and has projects from Sudan to Afghanistan, pretty much anywhere in the world where there's a problem he tries to help. And he flies there and travels there and has been to those places. He is now also a distinguished scholar of Sharia law. And then finally, there is, and I think that is the main reason why most of you will be here tonight, Rüdiger Wolfrum, the practitioner, yet another full career, and by now I'm quite convinced he never sleeps. He was a participant in the third UN Convention for the Law of the Sea conference. He was a participant in the fourth Special Antarctic Treaty Consultative Meeting. He was in the Preparatory Commission for the International Seabed Authority. He was a judge, coincidentally, in a German administrative court of appeals. And I think this is the reason for today's presentation, since 1996, he has been a judge, the International Tribunal for the Law of the Sea, of which he was vice president for 3 years and president for 3 years from 2005 to 2008. He served in numerous arbitral tribunals. I'm very, very happy he joins us here today, and I'm very curious to listen to his talk. Thank you.
Thank you very much, Rüdiger. You shouldn't believe everything. How do I work this here?
You can just press here.
That's another gadget. Okay, good.
The other one, that one. No, this one.
Ah, yes. Okay, good. Now, this was. Thank you. It's very kind to invite me. It's a pleasure, and I gladly said yes. I was in England recently, but in between I went back to The Hague. And therefore, you see, there is some dedication for the law of the sea. I will speak today about, as you see, recent jurisprudence of the International Tribunal for the Law of the Sea, and I will concentrate on procedural aspects. I do so for a couple of reasons. First, I believe that the major innovations in the jurisprudence of this tribunal, however also in arbitration, is on procedural aspects. At least I hope you will understand me after I've finished. Second, this sounds like blasphemy, but the law of the sea problems are actually quite limited so far dealt with. Those which still come up, I can't speak about, since these were part and parcel of the South China Sea dispute, which I will touch procedurally, but not in substance. This is the reason why I wanted to concentrate on procedural matters. Apart from that, you are having just established an LLM on that, therefore it's fitting. But here I can show more clearly the influence or the cross-references between various courts. And this is for me very important, that we can see the development. It's a development of the last 3-4 years. Let me explain the rules of the game. You can raise any question with me in between. It's not a problem for me. I will find back into the lecture easily. But if I have the feeling your thoughts wander away, I may be tempted to ask you. Therefore, and I have absolutely no hesitation to do that. This is a comparatively small group. In Germany, classes are much, much bigger. International law, I've been normally teaching before 100 students. And national public law, my biggest class was 700 students. Therefore, I'm not so easily frightened. Okay? These are the cases I am going to cover. I don't read them out. That's the benefit of PowerPoint, that you read and I don't. You see, these are all, the first cases are all cases of ITLOS. No, wait a moment. I've obviously haven't mentioned the others. The other cases I'm dealing with are from arbitration. And I have to read it out. There's no slide. I'll touch upon, briefly at least, the Bay of Bengal maritime boundary arbitration, not so much, but I will deal with Czechos maritime protected area, procedurally only, and with the Arctic sunrise provisional measure as well as in substance. I assume that you're all familiar with all these cases and you have read all these orders and awards. If not, you have to ask me. Okay, my first point. As you may know, it is for the Law of the Sea Convention, the jurisdiction of the Law of the Sea Tribunal as well as of arbitration is limited. It is limited in two ways. First, the Law of the Sea Tribunal is only called upon to give to judge upon disputes concerning the interpretation and application of the convention. And apart from that, we have limitations in Article 297, which apply automatically, and in 298, which have to be invoked. This is one element to which I come later. Before I come there, there's another provision. In the conference, it was decided, in the wisdom of those who negotiated this, that the states should have a choice. There are three options: ITLOS, ICJ, or arbitration. And the fallback position is arbitration. This is perhaps, I was not in this group, it is perhaps, so to speak, the compensation for the fact that as such the dispute settlement system is mandatory. At least it was seen that way. Now, states have to make a declaration. Well, they choose, and according to the last count, only 38 states have done this choice, give and take a couple. This is very difficult to understand why not more states have done so. The most obvious reason is they just have forgotten, or they don't care. Okay, this is what we have here. In the Bangladesh-Myanmar case, the two states wanted to bring the case before arbitration at the beginning. But then the presidents of ITLOS convinced them that it should come before ITLOS. For the president of ITLOS has a right to appoint, if it comes to arbitration, judges if the parties cannot agree upon them. And that gives him a certain opportunity, perhaps to drag the case away from arbitration to ITLOS. President Jesus has done that, and this is his case. Now, here we have two declarations, the one of Myanmar, the case was invoked actually by Bangladesh, and followed by Bangladesh. We have two declarations which fit. You can have a different interpretation, although it is in practical terms not very relevant. You can look upon these two declarations as ad hoc declarations. In this case, we choose ITLOS. That doesn't mean anything for the future. Or you could consider these two declarations as an agreement, a compromis. This is the alternative. Just to mention it, it's a fine point in international procedural law. The end result is not particularly, there are no differences between the two. That there could be or can be international agreements bound by two separate declarations is a well-known fact. These can be even letters. The famous letter between Copenhagen and Bonn on the Danish, or respectively the German minorities, are two letters. Nevertheless, this is to be considered an agreement, a very important agreement, on the protection of minorities. ITLOS did not take a position on that. This was left to one separate opinion or declaration by Tullio Trevis. Now, let me come to the next issue. And this is much more complicated. And here, I believe, somebody from civil law system has a certain slight advantage. This is a question of the scope of the dispute. This has not a long history in international jurisprudence. The issue comes up in the two circumstances. One, that's the old one, that a state changes its submissions in the hearing. Therefore, in the written part, it's one submission or a couple, and later something similar, different, or whatever. The question is, since the written part is decisive in that respect, can you change it in the hearing? And can you, as we had to deal with it in this case here, this is the M.V. Louisa case, can we deal with that? Does a court has a jurisdiction? You may wonder, why are we so strict in this respect? It's a matter of procedural fairness. Applicant and respondent act and react. If at the last moment the applicant shifts, or the respondent, in this case, shifts gear, the applicant mostly, then the respondent has very limited possibility to react properly. Let me explain, since you may not know the case that well. It was a case which was on its face, at least in the written part, a law of the sea case. A vessel, rather small, did seismic survey in the Gulf of Cadiz, allegedly looking for hydrocarbons, oil and gas. The Bay of Cadiz is territorial water or internal waters. What was a bit strange was that on this vessel there were archaeologists, which you normally don't expect when you survey for oil and gas. And we all know that roughly 38 shipwrecks are in the Bay of Cadiz, some from the period of Spanish colonization of Latin America, others from a later period. Very often warships sunk for whatsoever reason. When the Louisa was arrested, one found very little. There a bit of pottery was found, no gold coins, astonishingly. That was it. Now, the applicant, St. Vincent and the Grenadines, claimed that the arrest of the Louisa was arrested in the harbor, was infringing upon the freedom of navigation. The ship couldn't sail, sure. When we had the hearing, they brought a witness, namely the daughter of the first mate, who happened to be as a tourist on the vessel, and she was arrested for 2 days. The captain had left early on. Her father was in prison too, and she told us a story with many tears and whatsoever about the behavior of the Spanish police and the Spanish prosecutor and how unfriendly and so on and so on. Just to give you an illustration, the Spanish attorneys were dressed totally in red, or scarlet red, with gold and lace and so on. And after a while, we had the feeling we are dealing with an inquisition procedure. And one of the colleagues even later mentioned to me somebody wanted to kiss his ring before he was taken for a cardinal. He really looked like one. But this is a traditional dress for these universities, and these are very old universities. And it was quite impressive. Okay. Out of a sudden, the law of the sea case became a human rights case. And we were called upon to decide whether the right of fair trial or other human rights have been violated. We even were meant to look into torture and so on. It is not so that we couldn't do that. Some of us, myself included, have quite some experience on human rights issues. But we had started on a different foot. And therefore, this was an issue. The relevant provision is in Article 300 of the Convention, which is a catch-all provision, which says that in exercising its jurisdiction, coastal states should not abuse their rights. That's an abus de droit provision. Okay, what did the court say? This court said we have no jurisdiction, for this is not possible that we can look into this out of a sudden as human rights. The relevant cases are, for example, the case from, you see it here, Prince von Pless administration, and in particular later the Nauru case. Here you have it, Nauru versus Australia, where this issue was discussed. And here you have in paragraph 151 the end result. It has no jurisdiction. Here, this issue, however, comes up in a totally different dress, namely in the Mauritius versus United Kingdom case, the Chagos Archipelago, and also in the Philippines versus China case. Here the question is a different one. You remember what I said earlier? The Law of the Sea Tribunal has a limited jurisdiction. Limited due to interpretation application of the convention, whatever that means, and 297 to 298, which limited. It is the applicant's interest to try to submit submissions which are broad enough to suit its interests, but limited enough not to fall into the trap of going beyond application and interpretation, or 297, 298. For the ICJ, this is not a problem. The jurisdiction of the ICJ is so vast that you don't have to take that into consideration. It's only when somebody wants to change the subject. But here, in the case of Mauritius, Mauritius had certain submissions. I won't go into details. And the United Kingdom responded, this is all on sovereignty, and you, as a Law of the Sea Tribunal, can't decide on sovereignty issues. This is clear, the respondents. The first line of defense is always, the court has no jurisdiction. That's normal. This brings us to the central question, Who decides on what is the scope of the dispute? That is easy. It is always the court in question. But on what basis? In the case Mauritius, this was not yet very clearly, in my view, formulated and has been further elaborated upon in the arbitral award on jurisdiction and admissibility of Philippines versus China. There you have a clear-cut reasoning indicating what is to be said. I'll try to put it into one sentence. One has to distinguish between the application, properly speaking, what is called for, and the reasoning for that. And very often, sure, in the hearing this is always a little bit mixed up, but it is for the court to make that distinction. What is the application? Is it limited? And what is the background? That there's an old dispute, that's always very clear. Let me explain it in respect of Philippines versus China. It is absolutely no doubt that there is a dispute about the delimitation or about the sovereignty between Philippines and China. No doubt about it. However, as it has been explained by the arbitral tribunal in the award I referred to, the submission is very limited. The submissions, there are 15. Submission number 1, 2 are the most important ones in this respect, and 8 are the ones where the tribunal had to ask itself, can we decide the submission without touching upon sovereignty? In this case, the Philippines had clearly said, please don't try to decide on sovereignty. This was not as clear in the case of the Chagos Archipelago. But this is an issue which will going to haunt us in arbitration as well as in the dispute settlement system before the International Tribunal for the Law of the Sea. This is an issue now, the next slide, in the Provisional Measures case on the Arctic Sunrise case. The Arctic Sunrise case is, heard about it? Okay, I better explain it. Oh, somebody of you wants to do so? No, okay. Russia, by the way, equally so other states like Norway and Canada and the United States, is drilling for oil and gas in the Arctic waters. Environmentalists are concerned, and since I was heavily involved once upon a time in Antarctic business, for good reason. Oil spills in cold water, and certainly even worse on ice, never. Oil can be absorbed naturally, but it needs warm water. In tropical waters, oil spills are less dangerous. They are dangerous enough than in the cold water. We had learned that in Antarctica, a spilled bucket of oil will last for 500 years. That's a word. Okay. Therefore, Greenpeace is undertaking actions against these rigs. Not that they cut them off or something dangerous, but they do. They try to enter them and place a banner and say, we protest, that's all. The Arctic Sunrise, a vessel under the flag of the Netherlands, approached this oil rig of Russia. It was in the middle of the Russian exclusive economic zone. They sent a couple of rubber skiffs into the direction of the platform. Two, quite good, managed to enter the platform. 3 fell into the water. They were all picked up by the Russians. and flown back to the Arctic sunrise by a Russian helicopter. Those in water were properly dressed in warm water. 24 hours later, a Russian warship arrived and brought the Arctic sunrise to, which was it? One of the nasty ports in Siberia. I should remember the name, for my aunt had fortune or misfortune to live there for 18 years, Vorkuta. And later these prisoners were sent to St. Petersburg, where the climatic conditions are much, much better. The problem was, the only problem I'm mentioning in this context here is whether this was a measure which falls under the exception of Article either 297 or Article 298. However, in provisional measures, it is for the court not necessary to deal with this issue in greater detail, and therefore it was just bypassed. Having said that, let me switch to another issue, namely the issue of 290, which is on provisional measures. You know, provisional measures from your national law, and under the Law of the Sea Convention, we have two provisional measures to be dealt with by the Law of the Sea Tribunal, namely one according to Article 290, paragraph 1, and the other one according to Article 290, paragraph 5. The first one is the same as we have it before the ICJ. Provisional measures, I come to that. The other one is a little bit more complicated. As I've said, the arbitration is a fallback position, but it may be that before it is possible to establish an arbitral tribunal, there is a necessity for provisional measures. Therefore, you need the ordinary requirements for provisional measures, and secondly, you need that you cannot wait until this arbitral tribunal is being established. ITLOS has these provisional measures under Article 290, paragraph 5, quite frequently, without claiming completeness. One was the Planck case, where Sir Michael was participating. Another was the bluefin tuna case. The third one was a land reclamation case. This is another one on the Arctic sunrise case. And the Enrica Lexis is a further one. Now, if you believe that international tribunals, be it courts or arbitral tribunals, are always very consistent, you should wake up. They are not. To be, all my colleagues know it, I'm very critical about, we have not found a clear line how to deal with provisional measures. It's always, each time again, it is getting a new challenge. Sure, we do have very little time for that. Provisional measures are urgent cases, and they are received. Then we have a little bit of preparation in advance, actually 3 days. Then we have the hearing, 2 days. And then we sit for a week, deliberations, and then we must write the judgment. We finish very often provisional measures in 28 days from the date they have been submitted. No district court is able to do so. And this is having its price, particularly as it has been mentioned, if you have 21 judges. This doesn't make life much easier. Now, if you read paragraph, did you have a question? No, okay. If you read in the fourth line, which implies that there is a real and imminent risk that irreparable prejudice could be caused to the rights of the parties. And then we quote the MV Louisa case. This is already the first mistake. For the MV Louisa case, we were dealing with the case in the merits, and that has an influence. But be it as it may. Okay, we continue. This is, the 41, is the Ghana Côte d'Ivoire case. Here you have a quotation in quotation marks. A real and imminent risk that irreparable prejudice may be caused by. This is reference to the Louisa case. And so far it's okay. For this case, we are. This is the Atoko special chamber. However, read 42. 42 is now referring to the ICJ, and it repeats actually what is in 41, but not exactly. You see the difference? Now, care to look into the composition of the special chamber. The special chamber consists of a former member of ITLOS and the present president of the ICJ, Mr. Abraham. And the others are judges from the Law Sea Tribunal. Here, Abraham, Judge Abraham, or President Abraham, has had his say. And therefore, you have this discrepancy between 41 and 42 quite evidently. And now, please take into account the word urgency. If you look into Article 290, paragraph 1, there's no word of urgency. The urgency comes only up in 290, paragraph 5, namely, the case is so urgent that you can't wait for the establishment of the arbitral tribunal. But as I said before, we always mix it up and claim urgency for both. Sure, the ICJ refers to urgency too, and this is part of the jurisprudence, but we should be more careful. I have once said we have a double urgency. One, according to 290 paragraph 1, and additional 290 paragraph 5. That was considered typically law school professor. Let me now go to the most recent case, the Lexi case between India and Italy. It's a case which was highly emotional in India as well as in Italy. I was a couple of days after our order was issued in Italy, and all my friends were waving front pages, being very negative about this order, which I fear was in part misunderstood. And I received later newspapers from India, which were equally as negative. Therefore, we filled our task. If you can't keep them happy, makes them both equally unhappy, it's also a diplomatic objective. Be it as it may, I'll briefly explain the case, very briefly. It is actually a tragic case. You all have heard about the danger of piracy between the coast of India and the Bay of Aden, or the entry into the Suez Canal. There are several naval entities, units in this area, actually 3 different patterns, which don't coordinate very well, by the way, but that's besides the point. Piracy has declined in this area, but not due to the naval efforts, but more due to the fact that the mass media have lost interest. What's happening over years is not any interesting anymore. There are still a lot of piracy attacks. Not always very successful anymore. Now, as several states have taken different attitudes how to protect the vessels under their flag. And Italy came to the conclusion that its naval officers, petty officers, would do a very significant and efficient job in protecting these vessels. They put Marines, or they are perhaps different from the Marines of the United States, on board of these vessels to protect. Mostly it works by the fact of you spread the news and then you don't attack that vessel. Have you ever heard of a Chinese or Russian vessel to be attacked by pirates? You have never. For they have certain reactions. I once had a conference on piracy, and in the panel I was chairing in Heidelberg, there were 7 admirals. And the Russian admiral at the beginning raised his finger and said, I'm perhaps the only one who dealt with pirates directly. And we said, please tell us a story. Oh, he said, it was very simple. We were in the South China Sea with a ship which looked like a merchant vessel. You know what kind of vessel it was. We got a call for help from a fisher boat, and out of a sudden there were 12 men swarming over our deck, all with Kalashnikovs in their hands. Then he stopped a little moment and said, but we also had Kalashnikovs, and after the situation had been cleared, we continued our voyage. I asked the very silly question, did you report the incident to your government? He flatly said, what for? You see, this information gets around. And actually it's absolutely okay. Prevention is one essential element of avoiding war. Jean-Claude Moore has written a book about that and said most of the recent wars were triggered by insufficient indicating, stop here, not a step further. He quoted in particular the Hitler activities, the Munich Accord, etc. Be it as it may, it seems to work or should work. Other states are very reluctant to do so. Germany, for example, considers this not to be an appropriate mechanism. We put on our vessels private guards, which must be licensed. Still, the whole system doesn't work properly. Then most states are absolutely against merchant vessels carrying weapons into the territorial waters, let alone into the ports. And even if you declare them, you have lots of trouble. The only way out is to throw them all overboard before you enter the territorial waters and get something when you return, but this is not a very practical means. In the Louisa case, also one of the reasons why the Spaniards intervened were 3 machine guns, which this vessel needed against pirates in the Gulf of Cadiz, where I've never heard of a piracy incident. Be it. Okay. I tell you the story from the side of the Italians. The Italians describe the situation as follows. The Enrica Alexi has left the territorial sea of India, and at a certain point there was a fast approaching skiff, in a way approaching which was qualifying it as a pirate. The Marines opened fire and killed 2 fishermen. One directly and the other one died briefly thereafter. That's the story. The Indian story is not that much different. The place, the incident is all confirmed, only that you say nobody could have taken that as piracy. Here we stand. The Marines were first arrested in India. There was a diplomatic back and forth, which even resulted in a kind of a house arrest for the Italian ambassador to India. For the Marines were sent back to Italy, and he said they should not return. I leave that aside. Therefore, the tension was quite significant. Now, the legal question, in my view, is who shall have jurisdiction, or will have jurisdiction, to prosecute these two Marines? The argument on the side of Italy is these Marines are military, therefore they have immunity. They could also argue they were on an Italian vessel and therefore, so to speak, under the jurisdiction of Italy. Italy further argues that this was not anymore the territorial waters of India, and therefore invoked the law of the Sea Convention, that even in territorial waters, the criminal jurisdiction of the coastal state is limited. These are the arguments, objectively. On the other side, the arguments are there were two Indians killed, therefore we have the jurisdiction under general international law, and apart from that, these were on a fishing vessel under the flag of India. This was not for us to decide. For us to decide was a provisional measure initiated by Italy roughly 3 years after the incident, that the two Marines should have the right to be in Italy. For us, there were two problems. First, 3 years after the incident makes life a little bit complicated as far as urgency is concerned. And second, this submission application could have been seen as the end result. Therefore, provisional measures are not meant to give the final judgment. But the main deliberations were, it's not a secret, on urgency. What is the urgency in this case? Italy made very convincing pleadings in this respect, of which were countered by the other side. And if you go through the text, you will be a bit disappointed. No, it's here. There is nothing. We say at the beginning, there must be urgency, and then the notion of urgency never pops up again. Why so? I believe nobody has really understood, and it was an order which was, the vote was not so drastic, but the real split in the tribunal was very narrow. It was, I believe, the vote was 5 or 6 against, but if you read the separate opinions, then it's clear that it was closer to 9 to 12. But what the majority was seeking was to put the tensions of the two parties at rest. The objective of these provisional measures is to cool down everything. And therefore the urgency, if you want it, either to give it up, or, which one can, it's part of the jurisprudence, not part of the text, or to redefine urgency. We didn't do a proper job, I confess. This is when the court is very much split, you can't say that much in the reasoning. But the basic idea is we should make sure that this jurisdictional issue, who may prosecute, should be either decided by the parties by negotiation or by an arbitral award. And until that decision is being made, you keep on the national level the fingers off this case. The arbitral tribunal has by now been established, and we'll see how it is going on. I come to another issue, which is, here I'm quoting from the Louisa case again, or at least this is a reference. The problem which also the ICJ faces in provisional measures, that very frequently you say, yes, jurisdiction prima facie. Particularly in the ICJ case, Georgia versus Russia, the ICJ affirmed the jurisdiction of the court and later on the merits denied it. You always have an awkward feeling about that. Sure, as it's been said in 92, the question of jurisdiction to deal with the merits of the case can be decided only after consideration of the written and oral proceedings. This sounds very good, safe and right, but let's look at the Louisa case. The MV Louisa case, we accepted jurisdiction, and in the provisional measures, we denied it on the merits, on the grounds some of the, as already expressed in the dissenting opinions. Therefore, we could have reached that a little bit earlier. But be it as it may, one thing is absolutely clear. To decide on jurisdiction in respect of a provisional measure is something different from deciding it on the merits. And therefore, it is right to say that the decision on jurisdiction in an order does not prejudice the jurisdictional issue later on. This is again a Louisa on Article 300, which I have already mentioned. This is okay. One of the most very much disputed issues is Article 283 of the Convention, a provision which has always been misunderstood. You can't blame anybody, for the jurisprudence of the ITLOS is by no means coherent in this respect. 283 requires the parties to, after the conflict arises, expeditiously to negotiate, to consult on the means how to settle the dispute, not on the substance of the case. There may be a principle in general international law to that extent. This has always been mixed up. The problem we are having is something which is being produced by the ICJ, which is not properly read. For the ICJ, 283, unless the ICJ works on the basis of the Law of the Sea Convention, doesn't exist. Therefore, the ICJ in this respect applies general international law. We have arbitration as well as ITLOS, first and foremost, to deal with 283. And only then we have to deal with general international law. We have not got that straight. And we have, in the Louisa case, the threshold on exchange of views was minimal, saying it very positively. For the agent was already appointed before they started to exchange views, which is a little bit late in my view, but be it is. Still, this was considered to be sufficient. Okay, I had dissented on that, but the majority held it to be sufficient. In the southern bluefin tuna case, the threshold was higher, and in the Mox plant case, this was equally a significant problem. No, I did not put in, which is a mistake, the most recent decision in this respect. Oh no, it's China, Mauritius and later China. In the Chagos archipelago case, it's the first case who did it properly right. It distinguished between gave the correct interpretation of 283, saying they have to exchange views on the procedure. I know the United Kingdom argued that point very strongly. This exchange of view was not concrete enough. One can argue that. And finally, in the case of Philippines versus China, here we have the final development. Here is a clear cut. If you care to read, I do think I even brought the award on jurisdiction admissibility with me. Here we clearly distinguished between 283, exchange of views on the procedure to be followed, and then skipped over to general international law, exchange of view in general. We could take that luxury easily enough. For these two states have exchanged views on a monthly basis since 10 years. If that is not sufficient, what is sufficient? But finally we got it straight, and I believe this is one of the two elements where we have now a very clear-cut jurisprudence. It's the same is in respect of scope of the dispute and also in respect of the urgency in provisional measures. No, don't do. It's okay. I've been talking a bit too much recently. Let me come to another point, namely, also highly contentious, very much made problematic by the ILC, in particular by Alain Pellet. According to Article 295 of the Convention, before you bring these cases, there must be, the party in question has to exhaust local remedies. To extent this is required under international law. That is what is bad. What is required under general international law? We all know that in diplomatic protection, this is a must. No doubt about it. But we have a case which we call prompt release cases, where the vessels have to be released upon the application of the flag state. We always treated this like diplomatic protection, way off, until in the 2006 draft of the ILC on diplomatic protection, this particular issue was declared not to be diplomatic protection. We were informed by Alain Pellet that this was his doing. I don't know whether this is correct, but I always believe him. To the extent possible, for sure. And therefore, we have a problem. The release of a vessel, is this a matter for diplomatic protection and as a consequence, exhaustion of local remedies? What is the background for the exhaustion of local remedies? Very simple. You should first exhaust the national dispute settlement system so that the state concerned can rectify the situation. However, this is only in respect of individuals. Now, the prompt release cases are state-to-state cases. What is the function of the state in this respect? Is it to protect the individuals, or is it to protect its own rights, namely as a flagship state? If it were to protect the individuals, this is the case, Virginia G case. What do you do if the flag state, in this case was Panama, but the crew was not from Panama? Can you, as a flag state, protect people from Spain or Portugal, whatsoever? In a traditional diplomatic protection case, no. Leave aside the European Union, where this is being taken care of. Therefore, LMPLE is to a certain extent right. It is not the classical case of diplomatic protection. But how do we distinguish? In the Virginia G case, we said, we look at what is the preponderant element in this dispute. Is it the protection of the flag state's right, freedom of navigation, Virginia G, or is it something else? This was a tough case. 9 judges didn't believe that this was for the protection of the state, and therefore thought the exhaustion of local remedies was not done, which made life particularly complicated was that the owner of the vessel tried to exhaust local remedies and then gave up, which was an indication that there was a possibility. Good. However, this has also another problem, which is totally underestimated. How can you decide whether the local remedies were exhausted? You must look into the legal system of the state concerned. What do you know about the legal system of Guinea? You're all quite good at that, aren't you? Nobody of us was. We don't even can read Portuguese. Fortunately, we had an ad hoc judge to try to explain this to us. Unfortunately, his explanation didn't fit with the explanation of Guinea. And it further didn't fit, the two didn't fit with the explanation given by an expert. And therefore, we were scratching our head and saying, does Guinea really have the provide for the possibility for the exhaustion of local remedies? Secondly, was it exhausted? And third, why didn't they continue? Okay, at the end, we took the easy way out, said no exhaustion of local remedies, otherwise we would have had a significant problem. You can read it all in separate and dissenting opinions. They give you some further detail. Astonishingly enough, this was the first case where we had this problem, although we have done prompt release cases quite frequently. Here you have, it is well of customary that the exhaustion of local is a here you have what I just said, and here's also the reference to the draft of the ILC. And here is how we stated that. And this is what I just explained. I'm sorry, it's Guinea-Bissau, not Guinea. I'm always mixing the two up, but they're at least neighbors. It's all on the Virginia case, G case. Here you have in 159 the wonderful way out of the problem. We don't look into whether they were and whether they were exhausted. Let me come to a totally new element in international procedures, namely that out of sudden although this procedure is mandatory, states don't appear. The first decided not to appear was, by the way, China, but the first we had to decide on was Russia. I have the feeling Russia would have appeared if China had appeared, but I'm not so sure about it. Nobody tells you. One thing is clear. In that respect, one can wonderfully rely on the International Court of Justice, that non-appearing doesn't render the case moot. The party in question remains a party. The award or judgment remains binding for both. However, the non-appearance means a lot of difficulties. First, it means a difficulty for the appearing state, the applicant, namely, there is lacking the counterpart. And therefore, the arguments go into a dark hole or a black hole, for you don't know what the other side is saying. This was particularly so the case in Netherlands versus Russia. Sure, according to the rules, the tribunal has to work for the non-appearing state. But we would not know everything, evidently not. And for example, there's one major argument which might have been made. We couldn't deal with that, namely that the Rainbow Warrior case, the Arctic Sunrise case is a case of hot pursuit. What could have made that argument with a little bit intelligence, but it was never made since Russia never appeared. And therefore, it is certainly damaging also for the non-appearing state. I believe if Russia had appeared, it might have gotten a different judgment. In the case of Philippines versus China, we dealt with this issue differently, much differently. And I'm still astonished why so. Sure, I was involved in the order where this is not so relevant, and not in the case of the merits, but as two members of the arbitral tribunal in the case Arctic Sunrise are members in the case Philippines versus China. And still, the treatment of China was positively different from the treatment of Russia. Let me explain why, and I believe this is a fantastic innovation. However, I must confess, China also was helpful. China said right from the beginning, we don't participate. End of the story. When they pointed out in different diplomatic notes, etc., that they wouldn't do so. Then, when the memorial was sent to China, China was always kept fully informed and asked whether they would submit a counter-memorial. They kept the memorial, said they would not respond, but they made a, quotation mark, public statement, quotation mark. And this public statement was sent to each individual judge, which we rejected, for parties should not communicate with judges, and to the PCA, and was put on the website. And if you're interested in this case, please read this statement. It's well done, and it contains most of the arguments, not all, 90% of the arguments which China raised and could have raised. We had some more, but this is a very good job. We took this statement as an application for bifurcation, although China did not say a word about it. we decided that we would deal with jurisdictional admissibility in a separate hearing and judgment to accommodate the very stringent arguments on jurisdiction and admissibility voiced by China. Apart from that, it's no secret, every single document produced by the PCA was translated into Mandarin and submitted to China. Every press release, look at the last one, was in English, French, and Mandarin. English, French is mandatory. Mandarin. There were regular meetings between representatives of the PCA and the Chinese ambassador in The Hague. And therefore, China was 100% informed by each single step which was taken. No letter went out to the parties which did not go with a courtesy translation in Mandarin to China. All this was not done for Russia. Also not in the merits case, astonishingly. Sure, when we issued the award on the 29th of October, China reacted directly, same day, quite good, rather negatively, to say it mildly, but at least they can never claim they were not fully informed. You could see that they were fully informed. There is a very, very intensive writing in Chinese literature. We also translate from Mandarin into English and French, by the way, which proves that they have access to all these documents, not only the government, but also they spread it in the law of the sea community, the academic, etc. Okay.
Sorry.
Yes.
I notice that the decision on jurisdiction is actually in the form of an award. Am I right in assuming that the reason for that is because under Annex 7 an award is final?
Could you speak a bit louder?
Because under Annex 7 an award is final and binding.
Sure.
And therefore, even if now China decided
Yes.
to participate in the proceedings, they would be unable to dispute or revisit the
Yes.
questions of jurisdiction.
Yeah, the award is final and binding. I mentioned it right at the beginning, but could you bring it up again? Sure. The name award is maybe misleading. It is like a judgment from Nitlos, final and binding. Here, this is again on that, on the non-appearing of Russia. I have said it already. Okay, I go one step back. Yes, please.
I just want to follow on the last question, or comment. So you're not, with a non-appearing party, you're not moving to default. Rather, they seem to be continuing.
Mm-hmm.
If they were to appear, they would have lost whatever opportunities they had. Would you back up if there had not been an award?
No, I believe if China would move into, they would gain.
They would gain appearance, but you wouldn't go back
No,
and grant them extra time.
no.
They fall.
I wouldn't, now it's too late, sure.
Yeah, now it's too late.
After we finished the hearing 3 days ago, but they could have. We would have been flexible. And we announced it, we would be flexible. We would have appreciated if China had participated for two reasons, a policy reason. It is not good that this is a policy which is going to prevail. And secondly, it is, you are lacking a counterpart for the court and for the other side. It's very awkward. You sit there. I unfortunately was sitting on the left side and facing a couple of empty benches. Sure, it was quite well filled by our observers, but the first row was left had the signed People's Republic of China. Yeah. Apart from that, I don't have it on here in the slides, it's perhaps not that important. Namely, arbitration is normally confidential, behind closed doors. Can be different if the parties so agree. In this case, we stayed on the safe side. The Philippines were open in that respect, but we said normally arbitration is confidential. But there was so much interest in the region, and not only in the region, that, just a second, that we allowed observers to listen. And these are, in the jurisdictional phase, were only observers from the region, if you accept Japan to be from the region. In this case, on the merits, we even had more observers, also from outside the region. By the way, we excluded the United States for the reason that the United States is not a states party. I'm not going to discuss that point, for it was discussed very controversially. You had a question. Speak up, please.
Yes. So in formal procedure, China is not a party. But in substance, China has responded to
Yes.
the argument.
Yes.
So in substance, China is a party. But in the tribunal's procedure rules, eventually in the award to the issue, will China be regarded as a party or as a...
We read the award. China is a party. It only didn't appear. And as indicated earlier, China is bound by the award and will be bound by the next award on the merits. China didn't appear, but China has used, and very intelligently used, mass media, academics, and whatsoever to make known its opinion. In that respect, China was much more efficient than Russia.
Just quickly, does this mean China actually make a technical mistake by responding?
Yeah, China has made its case. If you compare the statement to which I have referred with the award, then you will see that there are only perhaps 20% issues which China didn't mention. For example, China did not refer to the Treaty of Amity, although this could have been an issue, and it did not refer to the Biodiversity Convention, although this could have been an issue, and it did not refer to, or did not state that the exchange of diplomatic notes could amount to a special treaty. These were the three arguments which were missing. But China argued 283 intensively, and in particular based its argument on the code of conduct in the South China Sea, which was adopted in the context of ASEAN. Whether this was a treaty was a question, and whether, if it was a treaty, we denied it, this excluded dispute settlement.
Yeah, maybe just quick follow-up. So if eventually in the war, China loses on all the applications, and the consequences of the award awarded to the Philippines will mean the sovereignty claimed by China will be severely constrained by the award.
No.
So will this be a factor? No.
First of all, let me not speak about substance. What we say on the merits, you have to wait a bit. As it has been established also by the Philippines, the arbitral tribunal has no jurisdiction to decide on sovereignty issues. Therefore, don't expect anything on that. Okay, that's the maximum I'm going to say on that.
But certainly the consequences will be a constraint on the sovereignty.
No problem.
say you should be acting in conformity with international law. It's not a restraint on sovereignty, in my view. Please.
Just a question relating to third parties, the observers.
You mentioned you would appeal before the international court. Nobody would understand you. Come on, speak up.
In relation to third parties, so the states that serve as observers, including states that have claims over the discrepancies, the tribunal said that it will examine the features which are not only occupied by China but also the other features in general. Would that?
This is all on the merits. We are not dealing with features occupied by, let's say, Malaysia or Taiwan or whosoever. And we don't deal with the relationship between Taiwan and China either. And we don't deal with a couple of other issues now. Okay, next time, perhaps. Let us go to my last point, advisory opinions. You all have heard, perhaps, that the Law of the Sea Tribunal issued an advisory opinion upon the initiative of a sub-regional fisheries organization on certain issues of fisheries, particularly about the obligations of flag state. For example, to what extent is a flag state obliged to ensure that vessels under its flag comply with international law, fisheries law, or even the national law of the coastal states concerned. These are the issues. This would fill another evening, for it's quite an interesting issue, but we leave it aside. Whether we have jurisdiction, I mean we, the tribunal, to issue an advisory opinion was highly contentious. The beauty, so to speak, of advisory opinion is that it totally changes the atmosphere. All responding to the request of the International Tribunal for the Law of the Sea on the issues at stake are trying to help the tribunal to find the right decision. It is not a controversial atmosphere, but a cooperative atmosphere. And we had plenty of interventions, and one can say roughly 50% said we had no jurisdiction, and some said we had jurisdiction, and there was a group who said if you have exercised jurisdiction, which we believe you should not, then it should be a limited one. These were, grossly speaking, these three approaches. I believe one of the problems of international pronouncements of that kind, they are not always well reasoned. And I believe, therefore, I take the opportunity here to try to show on what basis we have decided the tribunal has jurisdiction. The first is Article 21, which is here, all disputes and all applications submitted to it in accordance with this convention, and all matters specifically provided for in any other agreement. I underline, in any other agreement. It's not the same as first two. You must read that together with Article 138. First of all, according to the rules, it was for ITLOS itself to write its own procedural rules. It's not always the case. And here, it is said that the last rule of the rules may give an advisory opinion on a legal question, first jurisdiction. If an international agreement, please, I should have underlined that, related to the purposes of the convention, there's two further limitations, specifically provides for the submission to the tribunal of a request for such an opinion. Therefore, what you need is an international agreement relating to the law of the sea, which provides for asking for an advisory opinion. And then in paragraph 2, the next point, a request for an advisor shall be transmitted to the tribunal by whatever body is authorized by or in accordance with agreement to make their request to the tribunal. But this is a little bit tailored according to the rules of the statute of the ICJ. Therefore, it is, and here it is described in longer term, not that Article 138 of the rules gives us a competence to decide on advisory opinion, but it is 138 is only a clearinghouse. And perhaps we wouldn't have needed it for if the parties approach us on the basis of an international agreement. One might say the will of the parties is everything, but this is for clarification. And therefore, here we have the reasoning. There it refers to the applications, all matters, and then the argument that it is Article 138 of the rules which establish the advisory jurisdiction, and that being a procedural provision, Article 138 cannot form a basis, is misconceived. Right? It's not that way. Article 138 of the rules is, as I said, the clearinghouse, and only through it the international agreement comes in to play. Here, these prerequisites are a summary, an international agreement related to the purposes of the convention, specifically provides for the submission to the tribunal of a request for an advisory opinion, and the request must be transmitted to the tribunal, as I said. We applied, without saying it clearly, however, the medium approach by those who spoke to us. Namely, we said we are limited by the functions of the body which was asking the advisory opinion. Unfortunately, this has resulted in criticism of the advisory opinion. For that reason, we could not go into the high seas. We could not deal with the tuna in this area. And many other things we couldn't touch, for the functions of this regional fisheries bodies is limited to the exclusive economic zones for the states concerned. Therefore, we accepted this limitation, which is also derived, and therefore we did it, from the jurisprudence of the ICJ in this respect. But this curtailed our advisory opinion to the dissatisfaction of those who expected more. I believe still this is better to do it this way than going overboard. Here, I believe that it has jurisdiction to entertain the request, and this is limited to the exclusive economic zones of the member states. I wanted to bring that to your attention, for I'm particularly fond of advisory opinions. It's no secret. For I believe it is a big mistake to only rely on a contradictory procedure. There are legal cultures in the world, particularly in Asia, where going to court is considered, you don't do it. Therefore, you may go to an advisory opinion, which is not binding, by the way, but states may nevertheless listen to that advice. Perhaps I'm so much believing in this, I'm trained a bit in this respect. We have in German administrative procedure what we call Feststellungsklage, what's that in English? It's not an advisory procedure, but it is a decision which only states the law without going into facts. At least if the question is raised that way, or only states
the facts, but without raising the law. And the idea behind it is it's mostly used in cases where you don't have an individual but two state agency against each other. If they know what the law or the facts are, they will do the proper thing, we believe. Perhaps it's optimistic, but so far it has worked. Thank you very much indeed.